All right, welcome everybody. Thank you for coming. We're going to have a very interesting session today, and we have very qualified, esteemed guests that are going to speak to you about litigation in the space and how it's changing policy. And I first want to introduce myself. My name's Scott Cedar. I'm a former prosecutor and a former regulator, and I've been in the industry since 2013. And more notably, the last 2 years, I created and teach the University of Texas School of Law's first ever Cannabis Law class to second and third year students there, which I enjoy, and I'm happy to be here as a moderator. I'll let each of you introduce yourselves, and why don't you start, Lisa?
Okay.
Go from there.
My name's Lisa Pittman. You hear me okay? Got kind of a soft voice, all right. So I've been a commercial litigator for almost 25 years. And in 2015, I got started with cannabis law when I read the Compassionate Use Act. And when I read the mother's testimony about what their lives were like, taking care of these children, seizures all day long, what they were having to leave their families, their communities, their churches, their schools to go seek treatment for their children in another state, or maybe they didn't have the means to do so. And I had some personal motivations for why that spoke to me, and that lit the fire under me to get involved. And so I decided, whatever the risk was going to be to me as an attorney, because marijuana is federally illegal. And when you get involved with practicing law in cannabis, a lot of times the state bar will come out right away and say, that's aiding and abetting a federal crime. You can't do that. And then the state bar has to come back and make it okay for you to do it. But I decided, I don't care. Someone's got to do it. I'm going to do it. And so I went from there to Colorado. I moved there for a couple of years, and that was under the 2014 Farm Bill. So I was able to work under hemp back then. And back then, hemp was still marijuana. So ironically, it's kind of like right back to where we are today. So I already got a lot of experience in risk mitigation with the marijuana. I did a lot of competitive medical marijuana applications in a lot of other states. And then in 2019, I came back home to Texas. The whole reason to go to Colorado was to acquire all of that knowledge and experience and bring it back home to represent Texans whenever we legalize. I thought I was 5 years ahead of my time, not 10. We're still waiting. In 2019, I helped get the hemp law passed. And, I represent all kinds of different cannabis businesses all up and down the supply chain, all over the country. And of course, predominantly here in Texas. And so that's what I do. Yeah.
Go ahead, Susan.
Right. I'm Susan Hayes. I am also a Texas attorney. I'm board certified in civil appellate law, which is sort of where I started out my career. Also board certified in legislative and campaign law. And I have been lobbying for about 20 years in addition to litigating. I got into cannabis law because that would be the most interesting thing I could possibly do, and spent a little bit of time in Nevada right as they were rolling out adult use as the general counsel of a publicly traded cannabis company there, which terrified me. And came back to Texas, have been eyeball deep in the legislature. And one of my subspecialties is legislative drafting, helping fine tune language, both to try to accomplish the legal goal, but also navigate the political waters, which are very shark infested on this issue. Was very deeply involved in the hemp bill in 2019, and I've been pushing giant boulders up hills on medical cannabis every session since.
David?
So my name is David Sergi. I'm an attorney in San Marcos, Texas. I started off in California at a big law firm, and oddly, back in 1980 some odd, wound up writing a memo for a partner talking about litigation to try to legalize in California. Of course, that went nowhere many years ago, but I've been involved on and off ever since. Probably best known for a case involving Hometown Hero, involving Delta 8, involved in cases, again, all over the state, all over the country, from Florida back to California. Basically, we litigate. We don't try to do corporate work at this point. But we are, I think, sometimes at the bloody edge of the tip of the spear when it comes to litigation.
So I have a question for the audience. How many of you are attorneys? If you could raise your hand. Okay. So, before we start, to talk a little bit about commercial litigation, it's very expensive. And I think the people on this panel would tell you that advocacy is probably in the legislatures or the United States Congress is, while much more difficult to achieve, the objective is we'll call it a cleaner path to getting clarity for whatever the political objective is of the advocacy. And so what I think the purpose of this breakout session is to discuss the meaningful litigation that's taken place, mostly in Texas and some other places, to give all of you an idea of how advocates are using the courts to push the government to either do what it says it is supposed to do, or what the law is supposed to mean, or both. And so I think, just to sort of level set and align, I think that's an important place to start. And what we're going to do is we're going to have each of these esteemed speakers talk a little bit about what they think are important cases. And then we'll have some like a lightning round of questions. So with that, David, would you start with some of the cases that you think are important and give the people here a flavor of what those cases are about?
So I'm going to talk about two different sets of cases. One is a case probably no one's heard of, which is the Canna Provisions case, currently in the First Circuit, in which a very esteemed law firm, Boies Schiller, is actually challenging an old Supreme Court case that says the Federal Controlled Substance Act eliminates marijuana as a legal substance, and therefore it is the federal government has control over it through the Commerce Clause. And there's an old Supreme Court case called Reich, which they are seeking to overturn. It's a ballsy move, frankly, for the plaintiffs, because if they're wrong, then it basically leaves hemp as the only legal substance. And if they're right, then it's going to open up all the states to be able to properly regulate and properly manage marijuana as they see fit. So I think that is a very important sleeper case that's just being briefed right now, and it has tremendous, tremendous meaning for all of us in this space. Now, on the Texas level, obviously I represent Hometown Hero in a administrative challenge to the Department of Health's attempt to rewrite the definition of hemp. That's currently pending in front of the Supreme Court. We've got a great team of appellant litigators litigating that, but I think it's a very important case to watch. I think right now, essentially, the state has moved for review. It has been, I think it's going to be dormant through the session. I don't think we're going to see much action on it, and I think they're waiting to see what the legislature does before they make their ruling and their decisions. Then I'm also involved in the cases over in Allen, Texas. You may have heard of the raids. We represent a group of retailers. We are in the process of formulating a rules challenge to the Department of Agriculture's definition of hemp, because that's what the DEA is relying on in their attempts to get warrants, search warrants, etc. We're also involved in working and litigating against smaller jurisdictions that do not understand the laws that Susan helped pass, because we have sheriffs that walk into stores in Post, Texas and say, "You're not selling this stuff here," and take it all. And so we're in the process, hopefully, of settling that case shortly. But it seems like every day somebody calls us with some other problem with a smaller jurisdiction that does not understand the law. The last case that I will talk about briefly is a case we were involved with in Canyon, Texas, where they attempted to zone out by zoning regulation all cannabis and hemp shops. And I'm pleased to announce the city last week approved our client's application and has withdrawn those zoning regulations.
I need you to dumb this down, not for the audience, but for me, because I am not a litigator. And I think putting this in perspective of, say, let's see, I was a teacup licensee, one of the three, or let's say I was a state authorized dishes licensed hemp retail establishment. Tell me how the Boies case, the federal case that you were describing, what would that mean to me if I were either of those two things, if it was decided in the plaintiff's favor?
Well, if it's decided in the plaintiff's favor, then we continue as we are. And I think we have the ability to really structure teacups and structure our marijuana laws to fit what our state needs and wants. And I think that's something that Susan is probably far more qualified to talk about than I am. But if the plaintiffs are unsuccessful, then you're stuck back with the Rice case from the Supreme Court from 20 years ago, which says the Federal Controlled Substance Act eliminates marijuana as a legal substance. You can't do anything. It is a federal crime. And if it is a federal crime, then teacups, for example, is really at risk, because guess what? You have the Department of Public Safety in a state-regulated monopoly selling a federally controlled substance. And that is really a problem. And so if the plaintiffs are right, it really opens up the entire economic structure. If they're wrong, I think it's really risking shutting us down or requiring congressional action to either take it down to level 3 or to legalize it. But this case is going to be an agent for change, and I don't think too many people are really aware of it. And I think we really do need to be aware of it.
Got it. And the hometown hero case, if the plaintiffs are successful in that case, what will that mean for we'll call it the state authorized hemp establishments in the state of Texas?
Well, in that case, they can continue to legally sell Delta 8, which is what that case is about, and any other cannabinoid. And that actually goes hand in hand with the Fourth Circuit case that came out, whose name I do not remember right now, but it came out last week that said all cannabinoids are legal under the Farm Bill, and all hemp-derived cannabinoids. And amazingly, a very conservative Fourth Circuit Court of Appeals agreed with the liberal Ninth Circuit Court of Appeals and followed their precedent. So you kind of have this really conservative court agreeing with what the liberal court says, which hopefully will make hemp-derived cannabinoid products a federally licensed, a federally mandated and product that we can all sell without having to look behind our back continuously.
No, I have a question out of left field for you, Susan,
Yeah.
because I know you have such experience. Well, both of you have experience with the legislature here. If the plaintiffs are successful in the hometown hero litigation, do you expect any kind of legislative response or agency response from the executive agencies under the governor in the state of Texas? And what would be your knee-jerk reaction, not holding you to it?
Right.
What do you think, what kind of reaction could all of us expect?
An immediate backlash. And that's because of the political nature of the government in Texas right now. And the hometown hero case is in this, pardon the nerd lawyer take on this, but it's, I think, become kind of the secret weapon in the cannabis litigation wars is the Administrative Procedure Act. Every state's got one, federal government's got one. What it basically says is agencies can't just make up laws, put them on their website, and go forth. There's a process they have to go through, and the agency not following that process is the core of what the hometown hero case is about. So if they succeed and the Supreme Court rules in hometown hero's favor, the agency can then go back and follow the steps the right way, which they should have done in the first place, which will take time. That will take months and months and months. Or the legislature can pop through a bill, and then that's then about timing. And I do agree with David, it's likely going to be after session before the Supreme Court gets to that case. It's in full briefing now. There'll have to be oral argument. They take a couple of months to decide it, and then they usually try to get all their cases out in the summer. Legislatively, they're absolutely looking at this issue right now. We're going to see a bill one way or another. Question is, can it pass both houses, where we have a really conservative Senate led by someone who just hates everything about cannabis, and a House where I personally think we could pass a legalization bill through the House right now.
Got it. And then before we move to other speakers, I have heard and seen news stories similar to the case you mentioned in Allen, where there has been law enforcement interdiction in hemp establishments across Texas. Do you see this as a trend? And obviously, without revealing any confidences of any of the cases that you have knowledge of, do you have any theories about any of the of how and why this might be happening that could be shared?
Well, I mean, my personal opinion is that you have a very conservative police chief in Allen, Texas, who has had complaints about kids getting hold of vape pens and hemp-derived products. Now, vape pens are one thing. The other cannabinoids are really another thing. The legislature has not actually age-gated it. And I think best business practices are we should age-gate. We should not be selling to kids. We should be selling product that is attractive to adults, not kids. We shouldn't be selling Rice Krispie bars as best business practices. We shouldn't be selling nerds. We shouldn't be selling things that probably are a copyright violation. And that's what I tell my clients. Don't do it. Because even if you can technically get away with it, the backlash is what you're seeing. And so, I can tell you that a lot of folks are no longer selling THCA flower right now because of this, and they're waiting to get some clarity from litigation, which is about to be brought about what they can and can't do. Because my understanding of the warrants are they're looking at the USDA and the DEA definition of THCA flower, and that is not in sync with the Farm Bill. And so we can talk about that at length, but essentially they need clarity, and those are what the warrants are based out of. Now, I was involved in another case in Fort Worth, very similar case, where the grand jury, which is the entity that decides whether or not a case can go forward, we testified, had the privilege of testifying in front of the grand jury, and they did not indict, they no-billed. In other words, those cases didn't go forward, a very similar case, because the grand jury and the district attorney's office in Tarrant County wanted clarity from the legislature as to what they could and couldn't do, because it was a very gray area, too many arguments. And so all of my clients in Tarrant County, Fort Worth, got no-billed by the grand jury. Now, obviously, Allen is a different story. They are at the beginning of that process, but I'm pretty confident that once the district attorney's office looks at this closely, and my conversation with the DA's office is they really haven't looked at it that closely, they're going to come to the same conclusion that Tarrant County came up with, which is, let's wait for the legislature. Let's really wait for the courts to determine what we can and can't do. But right now, we're not going to prosecute this criminally.
So
that's my hope anyway.
So just for the audience benefit, my takeaways learning this is it seems to me that plaintiffs in civil suits are looking for clarity on their end. And it appears maybe law enforcement is doing what it feels whatever its objectives are to also get the clarity that it is seeking, which I think is interesting. But anyway.
Can I add one more thing?
Oh, go ahead.
For any of the attorneys in here, we are trying to form a state bar hemp section. And we've been talking to different people. I believe Kyler, I'm hoping, has a copy of our petition. If not, he'll have one later. Kyler Rucker works in my office along with Tony Fusco, who's here. We would like any attorney to sign it, because what we want to do is get the collective wisdom of this panel and other lawyers in this state to train younger lawyers so that we have enough lawyers to handle these cases across the state as they come up, and that we can actually have continuing legal education. Now, we won't be able to lobby because the state bar cannot lobby, but hopefully we can use that to have a foundation that can legally lobby like the family lawyers do. So that's my elevator pitch for that.
Right.
Susan, tell us, in your opinion, or tell our group here, what cases you think are important and why you think they're important and what they might mean in the big picture.
I will. And also, I neglected to explain during opening, I'm replacing Chelsea Spencer here today because she's out sick. Alas, I was looking forward to seeing her. But Chelsea and I worked together on the smokable hemp case, which was filed in 2020. When the hemp bill passed, the lieutenant governor insisted that some language go in it to ban the cultivation or manufacture of hemp for smoking. And when I first saw that language, I cracked up. I was like, do they not know you can smoke hemp as it grows out of the ground? Like there's no manufacturer to it. But the truth is they didn't. And that's part of the problem we have. We have people in power that we have to satisfy to pass a bill who do not understand the topic and don't care to understand the topic. Politically, we couldn't get it out of the bill. And my attitude at the time was, it's jacked up language. It doesn't ban smoking hemp. Let it pass. It's going to be a fun lawsuit later. And sure enough, it was. Who knew one of the biggest manufacturers of hemp cigarettes in the country was in Dallas. They were the lead plaintiff. A client of mine who has a CBD shop or a hemp shop in Austin joined in. And I truly was along the ride as a litigator. Matt Zorn was the lead litigator. Chelsea was on the case. And it was fascinating to watch the Attorney General's office try to litigate something they didn't understand. And that trend I later saw in the Delta 8 case. And David, I watched y'all's TRO hearing online during the pandemic and watched the Attorney General's lead lawyer vehemently argue with 1,400 people watching this hearing online that the only tetrahydrocannabinol that's legal in Texas, and quote, Delta 9 is legal if it's under 0.3%. And I thought to myself, 1,400 shop owners are going to be selling Delta 9 gummies tomorrow because the Attorney General has just said that's okay without thinking about the words that were coming out of their mouths. So the smokable hemp case, the agency, back to this Administrative Procedure Act, DISH has added onto that ban, DISH bans on distribution and retail sale, which was not in the original law, which was beyond the powers of rulemaking in Texas. So all four items are challenged, both the underlying statute and the regulation. You know, we win at the trial court, we win at the Austin Court of Appeals. At the Texas Supreme Court, we lose, but by then the agency folded on the distribution and retail sale. They didn't want to get an answer they didn't like from the Supreme Court. So you sort of call it a draw. What that left us with is people can just import it from other states as far as manufacturing. And in general with litigation, like as Scott said, litigation's really expensive and it takes a long time. Like you're looking at a good 5 years by the time you work your way all the way up to the high court, whether you're state or federal court. And it costs a ton of money. You got to hire experts. Lawyers are expensive. You need different specialists. Meanwhile, the legislatures are cranking along. So that timing can be important. But they do play a role, and it's part of a role of a strategy what Shane Pennington, who's another great cannabis lawyer, calls death by 1,000 cuts. All these little things add up. That Fourth Circuit case David mentioned, which is it's Anderson versus Diamondback Investment Group. It's been touted in the cannabis press a lot of, yay, all these synthetics are now legal hemp. I don't take it that far. And y'all be careful about what you read in the press, because that may not be what the case actually says, and it may not be how your jurisdiction treats it. What happened in Anderson is a woman got fired because she failed a drug test while taking hemp products and filed it's a labor claim. She ultimately loses the case. But in what's known legally as dicta, the court says that THCO and other synthetics are hemp. We disagree with the DEA and we agree with the Ninth Circuit. And the way I would describe dicta is it's really cool, court said it, but it ain't the law. And maybe another court follows it later. I mean, there is this sort of drip, drip, drip of the cases that you get that trend going. Same with the recent Fifth Circuit case, which is where Texas is, United States v. Conley. It's a gun case. Woman's husband loses his blankety blank and is outside shooting a shotgun in the middle of the night. Cops come, they arrest him, they question her, and they search the house and they find hemp products that are hers. They find marijuana. And they charge her under, it's against the law federally to have marijuana and a gun at the same time. And the Fifth Circuit struck that down as applied to a sober person. She's stone cold sober, watching her husband go crazy and get them all in trouble. She can't be federally charged for that. That wasn't because cannabis, that's because guns. And the Second Amendment is viewed so strongly in the courts, but it helps. It helps. It helps us start talking around the Capitol that, we need to, while we're at it, can we strike down that, corresponding state law about guns? and you can start cleaning up the law. And that is one challenge we have as a long game. There's so many hating on marijuana statutes in state and federal law. It's everywhere. And it's going to take a long time to get all of that out of our law, even if we so-called legalize. There's still other things that have to be repealed. And a last point I'll make about litigation and the death by 1,000 cuts. Culture matters. Public opinion matters. If you look at studies of the U.S. Supreme Court and when they rule, how they rule, they always go with the tipping of public opinion. Almost always. Very rarely, maybe certainly with the Dobbs case, do they go against public opinion. So the more we're talking to our neighbors, the more we're making friends with local law enforcement, the more progress we're going to make. And that's got to bubble up to the old white guys who tend to be our appellate judges, but it does eventually bubble up.
Susan, I have a question. I know that you counsel clients as well as act on their behalf in courtrooms. When these cases come out from various circuits, and let's say one of your clients reads about it in a trade association blog or whatever it is, how much import do you put on these cases? Because I understand in the business, a lot of the clients are looking for, we'll call it permission in some way, and you're going to have to sort of explain what this might mean in the context of DPS or dishes or wherever your client sits. Can you give the audience a sort of a flavor of how you counsel them? And Lisa, I want you to do the same thing because I know you do the exact same thing.
One of the first questions I ask people who are asking me, should I be carrying this product or doing this, that, and the other, is what county are you in? Because it's all a risk analysis. If you're in Travis County, even Dallas County, I know the DAs have personal opinions about this and have other fish to fry. They used to have official policies, and they no longer have official policies. And the reason for that, by the way, is the legislature passed a law that a DA can be sued and removed from office if they aren't following the law. And that was driven by the urban district attorney's office being won by progressive Democrats. So John Creuzot, the Dallas County DA, no longer has a public policy because he doesn't want to put a target on his back. Now, in practice, what's his office going to do? They're going to worry about the big fish because that's far more important to public safety. And that goes to public opinion. I had a conversation a couple of years ago with the first assistant in the Harris County DA's office asking, what y'all's attitude about this now? And his great one-liner was, the taxpayers of Harris County do not wish to see their money spent putting people in jail for a joint. And that's a powerful cultural reason. Now, if someone tells me they're in Burnett County or Montgomery County, I'm going to tell them to be a lot more cautious about what they're carrying. And if it's a gray area, you better be making enough money that you can pay the lawyers if you get arrested, if you get in litigation, whatever else. If you're going to take the risk, you got to be prepared to pay for the cost if you're the unlucky winner of the person who becomes a test case for local law enforcement.
Well, Lisa, when you counsel clients, let's say that this Fourth Circuit, a Ninth Circuit, what have you, it hits the blog, you have a client maybe in Texas, other places, and you're counseling in the same way. Are you looking at it from a perspective of a district attorney? Are you looking at it from a DEA perspective? Are you looking at it from a dishes or DPS? And do you make any distinction when these cases get handed down? As Susan said, they're often just dicta, so it's not like a ruling directly on the point that particularly your client may be calling you about, asking for permission.
Yeah, I advise them on all of that stuff. It's all a consideration. What Susan was describing when you have these cases in these other circuits, what she was saying is absolutely right. That helps at the Capitol. It helps with culture. It helps with everything else. But then as lawyers, when we are briefing the next case and we are asking the judge to hold a certain way, we're able to refer to those other cases. And so bit by bit, each one that we get is another one we get to add on and have more and more cases that are holding that these variations of hemp, if it's derived from hemp and it tests right, then the other cannabinoids in there shouldn't matter. One thing to be aware of is, for these raids that are happening, there's a lot of folks coming in from other states, the marijuana states like Colorado, California, Washington, Oregon, Alaska, Michigan, where in their states, the marijuana market is very mature, it's saturated, there's oversupply. Maybe the marijuana lobby has outlawed the hemp, so they can't really do much with their hemp. They've got insane regulations to follow and huge taxes to pay because they can't write off any of their business expenses under 280E. None of that is a problem under hemp, especially in Texas, where we just don't have enough manpower to really go after all of the retailers in the state. So these folks are coming into our state and they're just straight up selling marijuana with a hemp label on it or with a fake COA. The same thing happened with the Delta 8. So y'all should just be aware when you're buying products from your supplier, it may not necessarily fit. There is a legal argument for why THCA flower should be legal, but only if it is sold and tested and is compliant in a certain way. And there's a lot of other stuff out there happening. For example, you might just be getting shavings off the floor that have been sprayed with some kind of synthetic cannabinoid, and then they put a THCA sticker on there because that signals to the consumer, this is actually marijuana, you'll get high from it. And so then, the cop comes into the store, tests the product at the Texas Crime Lab, which is going to heat it, decarboxylate it, and that THCA is going to convert into THC 10 out of 10 times. And you're going to have marijuana, and then they can come back and get their warrant to charge you with felony marijuana distribution and seize everything in your store. That's not how your hemp compliance test is run at your friendly local hemp lab, where you can kind of get the test that you want from the lab that you want. So what I explain to my clients is that you're dealing with the only product that has the potential to go illegal on you, the only plant that has the potential to go illegal on you. And you are simultaneously subject to two completely different bodies of law that address the same subject matter, but they don't jive with each other. They're inconsistent. So you have criminal law is that one body of law. You have the Controlled Substances Act at the federal level. Every state also has its own Controlled Substances Act. Our state defines marijuana a certain way. It defines THC a certain way. That Delta 8 case it's not really about Delta 8 per se. It's about how our state decided to redefine THC to make all of them illegal unless it is that Delta 9 under 0.3 from hemp, sort of the opposite of the definition of hemp. So these definitions have been on the books for a long time. The punishment is your freedom. It's going to jail. And the way they test it, is a certain way, and there's certain procedures. Hemp was legalized under civil law, under the Farm Bill, and then it directs the Agriculture Department and the Health Department to come up with regulations to run the program and that you have to follow as an operator. So as a retailer, for example, when you're buying flour from a supplier, under the law, all you have to do is make sure that COA says that it's under 0.3% THC. As a retailer, under the law, you don't have to go test it again. You can just turn right around and sell it. However, under criminal law, if that product happens to be hot, meaning it is 0.4% THC or above, well, you are strictly liable for selling marijuana. And it doesn't matter what that piece of paper said or what you thought. It's kind of like, I will explain to clients, it's kind of like if you're driving in a car with a passenger and your passenger has cocaine and y'all are pulled over and you're searched and that's discovered and you didn't know anything about it, well, you might be charged and go to jail too, even though you didn't know anything about it. So I explain this to my clients and I explain, look, we need to have a protocol in place. We need to go over and above on our compliance because the prosecutor is not going to want to take a case before the jury. She can't win. First of all, she's going to have to explain that these complicated laws, and she's going to have to prove beyond a reasonable doubt that you had a mens rea, a criminal intent to sell marijuana. So what I tell my clients is make sure that you have copies of the hemp licenses of all of your suppliers. Make sure you keep all of those COAs. Develop some standard operating procedures where you decide you're going to test a percentage of your inventory each month and then actually go do some tests, some spot check testing. Keep all of that in your file. And, should something happen, then I can go along with your criminal lawyer and explain the law and bring your big compliance notebook and show, look, they did all of this stuff under the civil law that they didn't even have to do to make sure that they were only dealing with hemp. You're not going to be able to prove that they had criminal intent to actually sell marijuana, which, to be fair, like I said, that is what some people are coming into our state doing. And so some of the raids are because of, it's a conservative community. Maybe they were selling to minors. Maybe they were selling questionable products, and maybe there were complaints. But also sometimes it's just because they know the game, and so they're going to check it out. I believe there's almost 8,000 licensed stores in Texas. So you can just imagine there must be 20,000 stores. I get calls all the time after someone's been busted.
We got to get to your cases.
Sure.
Right. Can I add to what you said? Because it's
all right. Go
think
ahead.
of so many things.
But
Something my grandmother used to tell me: when they raid the whorehouse, they take the piano player too. Learned a lot from her. And the second thing that brings to mind, I had a call once from a guy wanting some advice. He said, I want to get a dispensary license. And I'm like, well, that's not a thing here. There's only 3 licensed medical cannabis dispensaries. Well, I'm looking, and I said, and they're in the Austin area. He said, well, I'm in Houston, and I'm looking one now, and this guy says he has a license. Sir, could you send me a picture of what you're looking at? Dude had a storage unit, like in a big storage facility outdoors, with a line out the door, selling a bunch of stuff he presumably brought in from California. And I was like, yeah, that's not legal. But he was telling people this is perfectly legal.
Well, I can tell you, as a former prosecutor and a former regulator, we had an old saying that the government is a lot like a dog. It knows the difference between being kicked or tripped over. Yeah. And when you don't put up those guardrails that all these people are talking about, that dog's going to bite you. I mean, that's just
show the government you're trying.
That's just how it is.
Yes.
And that you're a good operator.
I just wanted to add, that's another thing that I advise my clients is don't make products and websites and packaging that looks like it belongs at some skeezy, make it look more, high level. And I did want to say something, what she said about the county too, and just tell you about a case I was involved with that was interesting. And it was outside of Houston, and it was Montgomery County, I believe. And so I was working with my criminal attorney buddy there on this, and it was a shop that got busted. And here's how that one got worked out. You move that store over to Harris County, and we'll drop all these charges. So that's how, sausage gets made.
Lisa, tell us about a case that you've been involved with that would be important for our audience to know about in terms of how litigation is sort of pushing forward.
Okay, well, I could take us back in time to the early days of marijuana legalization. So back in 2015, 2016, actually, let's go back to 1970 with the Controlled Substances Act.
We don't have that much time. Come on.
No, so I'm going to talk about my amicus brief in Sicily versus DEA in the Ninth Circuit, which was filed in 2020. But just leading up to that, so y'all know, starting with when marijuana was placed into Schedule 1, governors and senators and all kinds of interested parties ever since have been petitioning the DEA to take marijuana off of Schedule 1 because it doesn't belong, right? I bet you everybody in this room agrees with that. Every single time they say, nope, no medical use, nope. 2016 was kind of a big year. We had several legalized states, recreational legalization and medical was kind of starting to become exponential. People were starting to talk about it and starting to notice. And so there were some high profile requests to reschedule marijuana back then. And in 2016, the DEA for the first time said, no medical use, but we're going to start allowing research. And here's a research application. So go for it. Well, 4 or 5 years later, not surprisingly, they took no action on any of those research applications. And so those same lawyers that Susan mentioned, Matt Zorn and Shane Pennington, they were, I believe they heard Sue Sicily, who's a doctor in Arizona, wanting to research how marijuana can help veterans with PTSD, but real marijuana. So another thing to know is before then, the only marijuana you could get was grown at Ole Miss, and it was powdery, moldy, and it wasn't
nasty skink.
it wasn't realistic. And so she wants to study, how does real marijuana that you can buy in a dispensary, how can that help these veterans? Well, she couldn't even get her application looked at. So this lawsuit was filed to try to force them to take action on her application. And veterans jumped in. I jumped in. I'm a non-resident fellow at the Rice University Baker Institute for Public Policy and the Drug Policy Program. So on behalf of them and on behalf of some researchers, I filed an amicus brief arguing the science and the medical arguments for, why this ought to be rescheduled, why the application should be granted, and why, the buzzword for that was untenable, because the petition that got all this started was it from an inmate?
Yes.
It was just a regular person did this one.
Yeah.
And he pointed out it's untenable that you can buy marijuana at the state level. You may even do your own little research with it, but you can't do anything at the federal level. And that's important for everybody to realize, is that back then, the biggest impediment to rescheduling was always the fact that there's no scientific studies that we will acknowledge. All of the medical use, that's just anecdotal. We don't believe in it. However, you were not allowed to research any Schedule I substance. So it was a circular argument that, and so in 2016, they said, well, we'll allow research now, but then they didn't. So that's what this lawsuit was about. Okay, it's been 5 years now, take action. And so that lawsuit was really effective in, I think the settlement of it was the Office of Legal Counsel memo was released explaining that one of their pretexts for denying or for not taking any action was some treaties. They were able to, as a result of these briefs that were filed, force the DEA to grant Dr. Sue Sistoly's license and to grant the other 32 applications as well. So now there is finally some research being conducted with actual marijuana that you can actually buy in a regular state dispensary. And one of my own little personal things that I was happy to do in that was to put a picture of what real nice bud looks like in the actual brief, which is rare to put a picture in a brief, compared to what was available to Ole Miss, and why it was so crucial that scientists actually be able to research actual marijuana that's being consumed by people with actual medical problems, and to actually be followed by scientists to see how they perform. And so now that has led to current day, where here we are, we're talking about rescheduling at 2:00 later. And so this was one of those death by 1,000 cuts. This was one of those little bitty, we're going to take this little chip off of the rescheduling monster, way back then. So that was pretty pivotal back then for what it was able to achieve and set forth for today.
What cases do you think, either filed or unfiled, would be the most important in pushing marijuana policy forward? And it's okay if you don't know, but I think it's a tough question to answer.
Yeah, there's not one single case. Because every case kind of tackles a discrete issue, so the one I just talked about tackled research and to lead toward a deschedule or a rescheduling. That smokable hemp one, the backstory on that was, this is again going back in time, back in 2018, 2019, hemp was really just talked about in terms of building materials and CBD. It wasn't really talked about in terms of you can get high from it. And so I'm presenting to all of these senators and representatives, and I'm on the TDA, Industrial Advisory Hemp Council, and, explaining all of this stuff. And there was a lot of skepticism, and it was like, oh yeah, right. This is just marijuana junior. Billy Bob's going to plant a marijuana patch in his hemp field. I just know it. And I'd say, oh no, they cross-pollinate and all this kind of stuff. We just didn't know back then. They just weren't doing it back then. And so back then, the only thing that they knew of that you could have fun with marijuana was smoking it. And so at the hearing on it before, to get it passed, one senator stood up and said, okay, well, if all of what you're saying is true, this is just industrial. You don't need to smoke it then, right? And the other senator said, no, you don't need to. So they put in there, the heading says manufacture and sale. So they were intending to address sale, but I think they thought, well, if you can't make it, then you can't have it. And they thought they were nipping it in the bud, and they weren't thinking of this little thing called the internet in the other 49 states. So of course we can still have it, but now it just turns out that our own, farmers have to send off their stuff to another state. We lose out on that little business aspect. So.
All right. Well, listen, I got to let David, what do you think? What case, filed or not filed, do you think is the type of case that will potentially push marijuana policy forward?
I mean, I agree with Lisa that a lot of the litigation addresses individual areas, and I think it's really dangerous to have a broad policy piece of litigation, kind of like in the First Circuit, because that has a potential of killing an industry or opening it up. And while I'm impressed with the lawyers, because Boies Schillers is an awesome firm, I think it's just a really gutsy, ballsy move. And that is one case that I think is going to have a lot of impact. The other case that I think will have a lot of impact is a rules challenge to the DEA and their interpretation of hemp. And that to me needs to be very well thought through. I welcome anybody's opinion, anybody on this panel. This isn't just, the show of one or two lawyers. It's let's put our collective heads together. Let's look at the idea of venue. Let's look at how to really challenge it. Let's think about the legislative issues that we have, lobbying. I know Mark Bordas is in here. I know several other lobbyists that are around. Let's really war game this lawsuit so that it benefits all of us and has the best chance of success. Because if we can do that, then we can eliminate a lot of the harassment that our retailers and to some degree manufacturers are undergoing. I want to say one other thing, testing. We really need to make sure that we deal with legitimate labs. I'm telling my clients right now, for example, in Allen Police Department uses Armstrong Labs. I may not agree with Armstrong Labs, but you know what? If Armstrong Labs has given you a COA, that gives you the best chance to sleep well at night. So, as Susan said, you got to think locally. I know that when we did the Delta 8 case, as you watched the presentation, all of our witnesses were veterans. Matter of fact, one of the plaintiffs is now the state commander of the VFW. We didn't put on folks that perhaps don't face up quite as well to old white men, but I'll tell you what, veterans sure do speak to them. You talk to people like Mitch Fuller, who then was the legislative policy director for the VFW, who's now the national policy director for the VFW. And when he speaks with the authority of hundreds of thousands of veterans, hundreds of thousands of people that are anything from MAGA carrying, hat wearing voters to left-wing liberals. Probably the most impressive thing I ever saw was going to the mid-year meeting of the VFW where Hometown Heroes was passing out samples and seeing MAGA hat voters, seeing long-haired hippies, but all of them loved the product and all of them gave great stories about why they were using it. And some of it is we have to shift the narrative away from, hey, this is just about getting high, to helping veterans with PTSD, helping people out that need alternative to opioids, and talk about the narrative that this is really something that our culture wants. You look at, I saw in MJ Biz the other day that there was a poll that, 80% of Texans want reform of marijuana laws. And it was just under 50% of Republican voters. This is not a red issue, not a blue issue. It's a purple issue. It's something that a lot of people can agree, but we have to get that narrative right and the right people to make that argument.
All right. We've got a lot of people, in this building that have vast experience at the Capitol and vast experience in the courtrooms. This is a little lightning round. Mm-hmm. Susan, what's going to be dispositive is how Texas is going to regulate. It's going to be decided by the lawyers or the legislators. You got a session coming up. What's your hot take?
It's legislators and it's maneuvering roadblocks and individual members of the session. And sometimes outside things can really influence that. And I'll try to be really lightning about this. We only passed any medical bill in 21 because a former Dallas Cowboys son had a seizure outside of the Senate chambers. while we were trying to push the medical bill through. And his parents were personal friends with the state senator whose wife saw it happen. Two other senators who were doctors were summoned to provide aid. And that's it. Something dramatic happened to someone incredibly sympathetic with the Dallas Cowboy star thrown on top. And so things like that can help push bills through.
So the Capitol, it's going to get solved at the Capitol. It's not going to be solved at the Supreme Court or a subsequent lawsuit. Your bet, you heard it here first. Susan Hayes says,
and not because the Capitol's better, even if if let's say things are descheduled or completely unscheduled federally, or there's some like as the Republic of Mexico, marijuana got legalized there as a constitutional right. You still have to have laws to regulate it. And that takes legislative action.
What do you think, Lisa? Do you think the legislature is going to somehow find a way to do this? Or do you think it's going to take, brave and capitalized litigants to push the courts to find relief?
Well, it's going to have to come from the legislature because you have to get the law in there first. And then the litigation comes to fix the law that was probably poorly written afterward. That's usually what happens.
I totally agree with you, Lisa. We're going to have to get a law and then we're going to have to litigate it. But that's our process in this country. And I think we have to embrace it. We have to have the right stakeholders pushing the right narrative. And we build that narrative at the legislature and then work with our allies, hopefully across party lines and across intellectual lines to get the result that we want.
Well, I think we're at the end of our time, Heather. I certainly have no problem opening up for a question or two, but I don't know what the policy. One question, who's the lucky winner? It's a question. I'll let you, Susan, pick it. You'll get to give a question.
It's been hospice nurse 15 years. You want a lawsuit? You talk to the families who have had to put their loved ones on opioids at end of life to where they couldn't make the memories with them because they were so doped up, whatever you want to call it, on opioids. You get all those people together and file a huge lawsuit. There's your lawsuit to move the policy forward.
Got it.
Because
that's a perfect litigant or spokesperson for that.
Yes.
Yep.
Good afternoon. So there's a couple of examples shared about litigation against distributors and producers. Is there anything specific to like the distribution tier of the network that you can reference?
I'll say that so far, I haven't had any suppliers or distributors get tagged. And I've had suppliers whose products are in these stores that were raided. But I guess they don't want to spend the manpower, the resource to go up the chain and do all that extra work that would entail. So, so far,
I would say that that's coming. And
I'm sure it is.
The takeaway from a lot of these raids. The questions are, where'd you get it from? Where are your COAs? And again, that's why, whoever said about having that book of COAs, it's so important to do this right. You cannot cut corners, Lisa. And I know that that's the advice that you give people, which is, make sure you do this right. I mean, I heard you in a pre-meeting talk about packaging. It is so right. It's so important to have the right packaging, and that's where your expertise is.
Well, listen, we're at time. Thank you very much. We're all available to talk to each and every one of you after we leave this room. Thanks for coming. I hope you enjoyed it. We certainly enjoyed putting it on for you.